This must be in judges' chambers.
All right, folks. This is the civil docket for Barron Circuit Court. Let me start by asking, are there any of you that have to get out of here to go join another call? If so, we'll try to get you further. I only have 3 or 4 cases on here, so I don't think anybody will be waiting too long, but if anybody's pressed for time, let me know. Okay. Our first case chronologically on the docket is 19 CI 604. That is Dilley versus CSX. That case came up for, I think what happened was it came up on the 7702 review. Mr. Baker, I believe, has since that time filed a motion asking for the case to be set for trial, I believe. So if that's where we are in that case and that's what we need to do, we'll get to looking at at some dates.
Judge,
Yes, sir.
Rod Payne here on behalf of CSX.
Yes, sir.
I don't think we're ready for a trial date, Judge, and this is the fault of both parties in this case. But after that lawsuit was filed, we've traded some written discovery, but that's it. And there's a lot of different reasons for it. But I think I propose that we just get a pretrial conference date and we come back in a few months after we've at least taken the deposition of the plaintiff and a few others, so we can tell the court we're closer to being ready for a trial.
All right, Mr. Baker.
It's okay with me.
Okay. Let's see. What if I gave you all, what if we looked at, something roughly 3.5 months down the road? Would that be enough time, do you think, to get some depositions scheduled, or would,
Absolutely.
things are starting to loosen up a little bit as far as traveling and things of that nature, but I'm certain we'll still have some issues.
That should do it, Judge. I think that's a good idea. 3 or 4 months down the road.
Is this a case that are we expecting, and I'm not going to obviously hold anybody to it. I'm just kind of trying to get my head around what we're talking about. Are we expecting expert witnesses and all of that, or is this basically just 2 different versions of the facts kind of thing?
I won't have any experts.
Okay.
It's not. It's a property damage dispute about some railroad work that was done at on this gentleman's land, Judge. I don't think it's an expert case. I think Matt, I'm sorry, I think Mr. Baker is right about that.
Yeah. Well, that's how it seemed to me too, just by reading the file, but obviously there's a lot that's going on that may not be reflected in the file, so I didn't know where we were. All right, why don't we do this? 1, 2, 3. Why don't we look at say the 21st or so of June, which is roughly 3 months and 3 weeks. So that gets us kind of right in between 3 months and 4 months.
Yes, sir.
And just put it back on for a pretrial. And then, as we get closer to that date, if you all need anything from me, let me know. If not, we'll get back together and talk on that day. And if I'll just pass the motion to set a trial until that day, so that we can take that up if we're ready without anybody filing a new motion. Okay.
It's a great plan. Yep.
Yes, sir.
All right.
Have a great week, Judge. Thank you.
All right. I will see you all then. We'll get an order out on that shortly. Okay. Thank you.
Thank you,
Thank
sir.
you.
All right. So that's 21 June, 9 a.m. Bank of New York Mellon Trust versus unknown heirs of Gifford, etc. That is 20 CI 143. Plaintiff's motion for a judgment and order of sale. In this case, we've got various governmental, defendants that have been served, and then we've got various, warning order attorneys that have been appointed for the rest of them. I don't see any reason that is not appropriate to grant the motion, but I'll listen if there's anybody on here that has an opposition to it.
Philip George, on behalf of the plaintiff, Your Honor. I don't believe anyone else is on the call. Tax bill's been paid. They're getting dismissed as part of this. We're carving out a piece for the state that they have through their taking, and I think all parties are in agreement here.
Okay. Well, you filed your motion some 3 weeks ago, and nobody has, I'm sure there's been some correspondence among all the folks involved, or at least some of them, but nobody's filed anything, and you tendered a proposed judgment with the motion. So I guess if anybody objected to that, they could have let me know. All right. So I believe those have been electronically filed, and I should be able to get on here in a minute when we finish up and get that signed. Okay.
All right. Thank you, Your Honor.
Thank you. The state of Bush.
Your Honor, Darren Mexick here for South Central Bank. I believe we're only here on two of my motions, but there may be some others. Everybody in the county is involved in this case, it seems so.
Yeah, all I was aware of was the motion to release the proceeds from the sale of some cattle.
Okay.
And then I think there's a kind of a technical procedural motion to amend your counterclaim.
There's also a motion by Monticello Bank to sell a deserted piece of property with no floor where there's no contest.
Oh, okay. I had not, oh, wait a minute. Yeah, I see that now.
Tendered February 11.
Yeah. I see that now. I'm sorry, I overlooked that.
Your Honor, and then on Kyle Baumgartner on behalf of Glenview, I don't necessarily have a motion, but I do have an update for the court regarding Glenview that may be of interest to others on the hearing as well at the appropriate time.
Do you want to talk about that now, or do you want to wait until after I finish talking about these motions?
It doesn't matter, Your Honor. I can do it now. I don't know that it'll impact your motions. It may. I don't think it will.
Yeah, that's what I was. I guess that's what I was asking.
I don't think it will to those motions necessarily, but Your Honor, for quite a few months, I have been working with several potential purchasers to buy Glenview. I can report to the court that we have a LOI that has been executed as of probably 3 weeks ago. We are diligently working on an operations transfer agreement and an asset purchase agreement. I can report that if those are in fact signed and approved by the bankruptcy court, there's going to be quite a bit of work to go back to the bankruptcy court, probably have a Chapter 11 plan amended, have the sale approved. But I can report, particularly to those on this hearing, I see Austin, I see Larry. What I envision is that the secured creditors of Glenview are going to be paid in full. The revenue cabinet would be paid in full. What happens with the unsecured creditors of Glenview, it's still kind of up in air based on how much money there is out of this sale. But I know that there are quite a few issues in this particular litigation before you, Your Honor, that relate to Glenview, relate to debts owed by Glenview. And if this sale does in fact go through, I am hopeful that it will clean up quite a few issues before the court.
Well, I must say I would be hopeful for that too, I guess.
We all would, I think.
I think everybody would be. I think everybody would. A rising tide would lift all these boats. You know.
Your Honor, I've reviewed the LOI on behalf of the state, and I have approved that for purposes of trying to assist with him getting securing a purchaser of the Glenview assets.
Okay. All right. I don't see that is. And Mr. Baumgartner, thanks for bringing that up. I don't see that it necessarily affects the motions that are pending right now, but that's good information to have because everybody needs to know. Let's, Mr. Hinton, I guess I think all of these were really filed right about the same time. So since you have one motion, let me go ahead and let you state yours, and then we'll get over to Mr. Mexick and let him state his two.
Mine's simply a motion for a judgment and order of sale as to a single abandoned property that Bush Jones LLC owns. The estate owns one half of the, I guess, the units in that LLC. There's a co-owner of the LLC unit, Stephen Jones. He did not guarantee the loan, and I specifically provided, as requested by Mr. Davis, that he has no liability whatsoever. This is just an order of sale with that 3% holdback we've been using.
Okay. And that is, let me see, you tendered a
That's
judgment.
596, 20 CI 5 or 56. Oh, that's the same one in all of them. Never mind.
Right. Yeah. No, I'm just trying to track down the judgment, but I see where you tendered a judgment with your motion. And it does address that you're talking about.
It is styled default and summary judgment in favor of Monticello Banking Company.
Okay. So is anyone present on this call in opposition to that motion? All right. There appearing to be no opposition to that motion. It looks like that should be granted. So Mr. Hinton, I can get those things taken care of probably today. Okay.
Do you want me to email you another copy just because your file's so thick?
No, I've only got the last about month in here. So I've only got an inch or two instead of the 2 or 3 feet worth of file that I had before they split them up. So no, I'm fine. And I've got your tendered order right here. I'm going to electronically, it wasn't electronically tendered, but I'll upload it and e-file it so that it goes out to everybody ASAP. Okay.
Thank you.
And there's a referral to the master, an order referring it to the master commissioner that went along with it. So that'll get put in there as
We've
well.
sent $200, Your Honor.
Okay, fair enough. All right, Mr. Mexick, your motions.
Thank you, Your Honor. I guess first one would be just the motion to amend our answer to include a counterclaim and cross-claim. The answer was filed prior to my involvement in the case, but there was no actual counterclaim or cross-claims to provide for, foreclosure of the collateral, the property. So I think most of it's already being sold, but I just want to go ahead and get that filed so that if we have to proceed with selling the additional properties, we'll have that ability. And I've seen no objections on that.
Okay, yeah, has there been anybody that wanted to raise an objection to that? Did you electronically, did you e-file an order on that or a tendered order? Do you remember?
Yeah, Your Honor, this one was, I don't know if you remember, I filed that motion about 2 or 3 months ago, and I think it was set for a hearing last month, and then court ran behind, and I think you had some criminal dockets up, so it kind of got shuffled, and with it not being that important, I didn't press the issue at that time, but I can double check and resend or refile another order.
Yeah, that would be best, because if that much time has gone by, it'll be hard for me to track that down, but if you could just upload another one.
Yeah, absolutely.
It'll pop straight into my queue, and I'll be able to sign it when I see it. Okay.
Okay, great.
All right.
I'll get done today.
Super. Now let's talk about
the next.
Yeah, let's talk about the next.
Sorry, Your Honor, go ahead.
Go ahead.
It's just a motion to release funds that I believe Mr. Davis is holding. I've spoken to him or through email, and Mr. Davis, I tendered a new order that has the 3% holdback. That order got tendered, I think, last week, maybe late last week.
Right.
And I don't know of any other claims to those funds. South Central Bank has from what I know, is the first and only lien on it, other than arguably Mr. Davis's claim for the fees. So I included the 3% holdback.
Okay. Yeah, and that just seems to kind of be a rule of thumb that we've been applying in these distribution related orders. So with that, Mr. Davis, I have that version 2.0 of that order with the 3% holdback on it that has been tendered. So with that modification, are you taking any opposition to the motion?
No, sir.
All right. Is there anyone else on the call that is opposing the motion? All right. That one, I'm not sure if that one got e-filed either, but I have a hard copy of it. And so I can upload it if there isn't one in my queue.
I've e-filed everything in this one, so I can, if not, I can do it again.
Yeah, we can take care of that one. If you'll just resend through the e-filing the order allowing you to amend your cross and counterclaims.
Okay.
That's all I need. Okay.
Yep, I'll get that done today, Your Honor.
Yeah, we can take care of everything else. All right. As far as the
Thank you.
estate of, okay, as far as the estate of Bush, is there anything else that anybody needs to say? All right. Mr. Baumgartner, thanks for your update. If there isn't anything else, then if you're here for that case, you all can be excused. Okay. Thank you.
Thank you, Judge.
Thank you, Your Honor. Thank you, everybody.
This is 20 CI 566, which is Firkin et al. And versus Coomer and Duval versus Coomer. This
Good morning,
is,
Your Honor. This is
yeah, go ahead. I'm sorry.
this is Martha Brown. I'm here today for Margaret Coomer, and this is our motion to compel all the plaintiffs, with the exception of James Duval, to respond to outstanding discovery requests. We served these back in October, and I had conversations with Mr. Gillenwater in the interim as to whether he intended to continue representing the plaintiffs. I've not received a response to the motion or a motion to withdraw, so I assume that he's continuing to represent them. So this is my motion, just asking that those outstanding discovery requests be responded to.
Okay. And I see Mr. Brown on the call. Mr. Brown, you represent the Duval intervening plaintiff, correct?
That's correct, Judge.
All right. So we don't have a beef with Mr. Brown, right?
That is correct.
All right. All right. Yeah, I mean, obviously you're entitled to have your discovery requests responded to. And you know, I understand this is, and I'm sure you know, Mr. Gillenwater's got a lot of health issues and certainly has been, his situation's been one that we've had to do this in a couple of other cases because he's had a lot of trouble being able to even to leave his house. He's had, you know, some surgeries and some different things like that. And he's would fall into a high risk category from the standpoint of the virus. So I understand, you know, if he's struggling with getting some of this done. And I think the important thing to do is to get some sort of deadline, you know, rather than just the general 30 days that's in the discovery rules. I mean, it seems to be more impactful when there's a court order of what I've discovered over the years. So that gives you something you can show your clients at least and say, hey, listen, you know, it's put up or shut up time. So I'll give you that. Did you talk to him at all about any time frame that you might be asking for? I mean, I know you don't want to wait 30 more days.
Well, I actually, my request was for the responses to be provided within 30 days.
Okay.
I actually was not aware of Mr. Gillenwater's present health condition, so I'm happy. Obviously, if 30 days is not enough, I'm fine with extending that. But the request in the motion was for 30 days. Okay.
Well, that's fair. I mean, that's abundantly fair because 30 days is all you need. You know, supposed to get anyway. And, you know, this is coming up a lot and we've been giving people a wide berth on this because clients, especially if they don't live in the same community or whatever, it's a lot tougher. They can't come to the office. And I honestly don't know if Mr. Gillenwater's even been in his office since all this happened. I don't think he has. So he's working from home and, you know, that's tough. It's in the best circumstances, you know, but 30 days is fair and I will sign. Did you tendered an order, right?
Well, you know, I thought that I had, but I could not, as I was sitting here, I couldn't find a copy of it. So if I have not, I will certainly do that today.
Well, yeah, I don't have one. So that obviously could mean that there wasn't one tendered, or it could just mean that they didn't print it out and put it in here. But if you're not certain, why don't you just e-file just tender one through the e-filing. And what you might want to do is shoot an email to me when you've tendered that so that I know it's been done. I'll be in court all day anyway, and I probably won't get on and look at my e-filing until tonight after I get finished with court. So as long as you get it done sometime today, I'll get it.
So we'll do that today.
If it's tomorrow, that's fine too. I mean, just whenever you tender it. And if you want to, I'll tell you what, if you want to do this, since today is the hearing and you've asked for 30 days, if you want to go ahead and just put a specific date in there, like March 31st, so that there's not a question about when that 30 days starts and stops.
Absolutely.
Okay.
Thank you, Your Honor.
All right.
All right,
Thank you.
And that's all I had, if I may be excused.
You bet.